Good morning, everybody. My name is Paul Santamaria, and I'd like to welcome you to this morning's seminar on the ins and outs of sale of land contracts. It always amazes me how alluring the topic of sale of land is to bring so many people out at 7 o'clock or so in the morning to come to discuss the topics. I must say that having read the papers, and the advantage of reading both papers that we're hearing this morning, having read them last night, I think it's going to be a very full session. And so what I'm going to do is very briefly introduce each of our speakers. We're going to begin this morning with the paper given by John Styring. John I've known for a very long time, actually, for longer than we probably would care each to admit, John. But John is someone who has practiced in commercial law at this bar and practices in the Supreme Court and the Federal Court and also the Supreme Court of New South Wales. Recently his practice has included a wide range of banking and finance cases, issues arising out of corporate insolvency, such as preference actions and the liability of directors for insolvent trading, which is always a pretty hot topic around this part of the world, extending into Part 5 trade practice cases, professional negligence cases, and I know that John has a particular interest in the area of restitution. So can I ask you to welcome John? His topic for this morning is promises, conditions and contingencies, a challenging topic for any hour of the day. I think you would agree, John, but we're looking forward to hearing from you this morning.
It's not hard just to get a little bit excited about the classifications of terms in sale of land contracts. It's really right up there with equitable stoppel, isn't it, in getting that nice inner warm glow at about 7:15, 7:30 of a morning. Look, I've prepared a paper, it's there to be read. I want to just lightly scan its content and flesh out some matters without reading through it. Most contracts, including those containing flaws, error and inexactness, are carried through to completion. And why? Because the parties want to see the contract completed. But when flaw, error or inexactness are relied upon by a party, essentially to get out of the contract, we're concerned with an essential question. What did the promisor really promise? From beginning to end, the question is addressed by reference to what? The words of the contract, a construction of the contract. And in the particular context of the sale of land, a real understanding about terms, a classification of terms. And it's in the area of contingent terms that many of you have seen significant stoushes from time to time in relation to contracts for the sale of land. A party may express the performance of a contract to be contingent upon the occurrence of a specified event. The rationale being to enable one or more, all of the parties to the contract, to be relieved from the performance of their obligations. The effect of such a term is a matter of construction, understanding the words used by the parties. Can I give you some brief examples of contingent conditions, contingencies? This contract is entered into subject to the purchaser completing a sale of their property at whatever the address is. This contract is executed by the parties subject to the purchaser or his nominee receiving approval for finance on satisfactory terms and conditions. This contract is subject to the purchaser obtaining development approval from X Shire Council. In the leading case of Perry, whatever, against Coolangatta Investments Proprietary Limited, the obligation to complete the sale of land contract was made dependent upon fulfilment of a condition or contingency that the purchaser's property, Lilly Pilly, first be sold. The contract of sale was made in April 1978. Lilly Pilly was only sold in June 1979. In September 1978, the vendors started a proceeding in the Supreme Court of New South Wales claiming that the contract had been terminated the month before. The purchaser cross-claimed for specific performance. If you just bear with me for a moment, there's a nice little passage by Justice Wilson, and he said this: in the meantime, there was a conditional contract in existence from which neither party was at liberty to withdraw at will. Interim obligations were undertaken by both parties. The vendor had to make good its title to sell, and the purchasers were obliged to pay the deposit and make all reasonable efforts to bring about a sale of the Lilly Pilly property. That is to say, even although the contract was entered into subject to the purchaser completing a sale, it wasn't a condition that went to formation of the contract. It was a contingency, and courts prefer to say there is a contingent condition rather than a condition going to formation of the contract. I want to see that the contract is on foot. Parties have done things, deposits have been paid. And so Justice Wilson said. In his disposal of the case, the Chief Justice, Sir Harry Gibbs, put it this way: I consider that when the time has elapsed for performance of a condition, which is not a promissory condition, but a condition precedent to the obligation to complete a contract of sale, either party, if not in default, can elect to treat the contract as at an end if the condition hasn't been fulfilled or waived. Just pausing there, if it is clear that a condition in the contract has been inserted for the sole benefit of person X, that person can of course waive it. Continuing, and that it's not necessary first to give a notice calling on the party in default to complete the contract or fulfil the condition. What I've said, not me, Sir Harry Gibbs, is of course subject to any sufficient indication of a contrary intention in the words of the contract itself. Examine the words, read the words. What did the promisor really promise? How a term will be regarded by a court, either as one going to formation or only going to performance, is what? A matter of construction. Read the words. What was intended? Where parties have settled the terms of their bargain, Australian courts tend towards the view that contingent conditions bear upon performance rather than formation. we need to be very clear with our terminology. We see the expressions condition precedent. Many think that is a condition precedent the operation, the formation of the contract. Not always so. A condition precedent may be another expression simply for a contingency. And what is a contingency? An event to which future performance under the contract is subject. Can I return to the Coolangatta case? The prevailing view in the High Court was that despite the clause in that case being in terms of this contract was entered into subject to XYZ, the clause went to performance, not to formation. We then jump to the question you all have in mind. Well, when must the condition be met? There are a series of rules. Please bear with me. Where the contract contemplates a fixed date for completion of a contingency, a fixed date, and stipulates that time is of the essence, it's clear that the condition must be completed on time. Simple. If the contingency isn't met within the stipulated time frame, further performance of the contract may be terminated by whom? The promisee, the person to whom the promise is owed. Where time isn't of the essence and the condition hasn't been fulfilled on time, the promisee should first give notice, making time of the essence. Where a precise time for performance isn't fixed by the contract, the condition is to be fulfilled when? Within a reasonable time, which was the essence of the contract. Upon expiry of the reasonable time, the party entitled to terminate by reason of non-fulfilment of the condition or the contingency can do so, and without giving notice. Now, the obvious flashpoint is what amounts to reasonable time in the particular circumstances. And about that, reasonable minds may differ. It is all factual. It is all dependent upon the terms of the contract. Can I focus upon exactness and have you turn to paragraph 34 of the paper? In the high mast case that I've referred to in that paragraph, 3% was the tolerance difference between the area of land sold and the permitted reduction of area on a plan of subdivision that was to be registered and to which the contract was subject. The plan registered provided for a reduction of area of 3.015%, the difference of not some large amount. Now, one would think that the purchaser could successfully argue, well, I beg your pardon, one could think that the purchaser would have received substantially what it had contracted to purchase. Not so, said the Court of Appeal of Queensland. There is a need for exactness, not only in relation to breach of contract, but in relation to the performance of a contingency. Can I next address matters of cooperation, the duty to cooperate? The duty has two aspects. First, a duty to enable the other party to have the benefit of the contract. In the GR Securities case, Justice McHugh in the Court of Appeal of New South Wales said this: under the agreement, each party was obliged to do all that which was necessary on his part to enable the other to have the benefit of the agreement. At a minimum, parties to a conditional contract owe at least the implied obligation not to obstruct a fulfilment of the condition. There's a second aspect, and that is to imply that a party is to make all reasonable efforts to effect fulfilment of the condition. In the Coolangatta case, the contract for sale of the land was subject to earlier completion of the Lilly-Pilly property within a reasonable time. The High Court unanimously concluded that the clause carried with it an implied promise of the purchaser to do what was reasonably necessary on his part in order to fulfil the condition. A sale of the Lilly-Pilly property more than 12 months after the primary contract for sale wasn't good enough. Justice Brennan said this: of course, the purchasers had the carriage of the sale of their Lilly-Pilly property, and the stipulation imported an obligation upon them to do so, to do all that was reasonable on their part in order that a sale of the property might be completed. But that was the extent of their promissory obligation. Their obligation wasn't to complete a sale of their Lilly-Pilly property, but to do all that was reasonably necessary to effect that sale. Can I go to another scenario? The contract of sale is made subject to the purchaser obtaining satisfactory finance. The same considerations apply. Likewise, as we've seen in relation to the Queensland case, if there is to be registration of a plan of subdivision, that's got to be done within a reasonable time, and in that case, approval is to be obtained within a reasonable time if time isn't fixed otherwise by the contract. What I'm about to say isn't terribly helpful. It's the Swerve Room provided by the courts and by lawyers generally, but where a party has failed to fulfil its obligation to cooperate, the assessment by a court as to the level of breach involved will be viewed having regard to the nature of the condition and the particular circumstances of the case, the get-out statement. Can I now address termination upon non-fulfilment? Where there's been non-fulfilment of the stipulated condition, contingency, termination rights will depend on context. Where a contingent contract fixes the time by which the condition is to be fulfilled, the contract may be terminated if the condition hasn't been fulfilled when the date arrives, and without the necessity of the other party giving notice. When the time has gone by for performance of a condition that is not promissory, but what I call a pure contingency, or using the expression of some of the justices in the High Court in the Coolangatta case, a condition precedent to future performance, either party, if not in default, can elect to treat the contract as at an end. Again, subject to the question of waiver. As to the doctrine of election, the general view is that contingent conditions, if not met, do not result in a self-executing termination of the contract. There is still a need to make an election, and then to do what? Communicate the election that you've made to the opposite party of the contract. But there appears to be an exception in terms of election, and that is where fulfilment of the contingency is beyond the control of both parties. We see from the Coolangatta case and other cases that have followed it that the effect of a valid termination upon non-fulfilment of condition is the same as if the contract had been terminated for breach. Future performance of obligations under the contract are brought to an end, but accrued rights are preserved. This has been quite the merry little dance in many ways, and we waltz around the words of the contract, but we pay attention in the performance to the terms used by the parties. Unless close attention is paid to those words, both in terms of you're acting for one of the parties in the preparation of the contract, what does my client want, or if there is dispute, what is the get out of all of this? Unless close attention is paid to the words, we can't answer the fundamental question, what did the promisor promise? Can I leave you and to work out for yourselves the connection between the heading of my paper on the top of the first page and that which is set out on page 13 with the reference to Lewis Carroll. Thanks for your time.
Thank you, John. I love your expression, Swerve Room. It reminds me immediately of a morning in the Court of Appeal. And until hearing your reference to Swerve Room, I've always felt more comfortable with the more dramatic expression of any port in a storm. But thank you for especially your exposition of the principles in Perry and Coolangatta. I think for most of us, the reasoning and concepts of contingencies and conditions has been until now quite elusive.